I'm going to get started since you guys were on time. And I'm sure there's another event going on in our market center as well. So I think there was maybe a conflict of schedule. So I'm going to go ahead and get started and talk about a couple of things. This particular broker chat is held by myself and Tom, our qualifying broker, and it covers the heart of Atlanta. For those of you, I know, Adam, you've been on a few times, and sometimes we have some new people on. So I just wanted to explain what this actually is all about. And this is an opportunity and a platform for you to ask your own broker questions, or if you have a scenario that's going on that you need some assistance with. And because it's a platform with a broker, and you also have your colleagues on here, so people can share their experiences as well, things that have worked for them as well, or didn't work in some cases. I am the managing broker in the Midtown office, and so I handle everything that has to do with good, bad, and ugly, GREC and lawsuits and answering questions, talking to your buyers and sellers when they are upset, and so on and so forth. So when that happens, I kind of compile all those type of scenarios that happen to teach teaching lessons, case studies. It's always good to hear real life stuff because you may be listening to something saying, wait a minute, I'm going through that right now. So we'll talk about some of those things. Would someone let me know whether you can see my screen or not?
I can see it. It's a skill set market.
Yep, sure can.
Yes, perfect. Thank you so much. All right, this is your forum. When there's not immediate questions, I will usually have a topic. And so if there's something that you are on this call for today or this Zoom today, just jump in and say, hey, I have a question, and let's discuss it. But I like to have an agenda just in case I have a quiet crowd, which we've got some top producers on this call, so I doubt that it'll be quiet. There might be some oohs and ahs and what did you just say? And that's okay as well. This is a safe space. So the first thing we're going to do is kind of go over the GAR mid-year changes. There were not a lot of changes. For those of you that wonder what is that, Georgia Association of Realtor, our contracts, they are renewed every January. And then they are updated mid-year because lawsuits, misspelled words, grammatical errors, repaging of numbers, repaging of reparagraphing numbers, and things of that nature. So anything that was missed in the January publishing is corrected in the mid-year. And then if a lawsuit has been settled and Seth Wiseman and Wiseman Group and the contract committee decide it needs to be in our contracts to protect us, that is called the mid-year changes. They usually come out in April, but we are in this new world order of real estate, and the mid-year used to just happen once. Now it's starting to happen, maybe 2 mid-year changes. So this year it came out in June. Normally it comes out in April, but it didn't show up until June 1st this year. Then there was a coming soon update. I get calls about coming soon all the time. If you have questions about that, jump right in. I'm going to talk about what the coming soon looks like. I thought it was going to be ixnaying it. They did not. They just kind of made it a little bit more flexible. And then Tom asked that I talk about the 10-day letter process again. We're having a lot of trouble with that. I haven't had any lately with it, but I just want to touch base in case there's someone on here that's not familiar with that process. So in the chat, you should have this handout. I asked Niala to put that. Do you guys see the handout in chat? Let me see if it's in there. Oh, there it is. Zoom Assist just put it in there. All right, and what the handout is a copy of the slides. So if I went too fast on something, or if you wanted to print it or type your own notes as we go along, you have it. When we have a revision to our contracts, you will see in your package, either in Remind or FMLS or Georgia MLS or Command, whatever you use to create your, or dot loop for some of you, whatever you use to create your contracts when you're writing, then you will find the very first document would be the revisions, then your index of forms, and then your index of special steps. So 2023, anything that you see circled or not, where it says new, that means they either changed the paragraph and there's some new verbiage, or I didn't highlight anything that said, oh, we changed the letter G to a B. We don't need to know that. We're only going to talk about the things that impact your day-to-day writing of contracts. You can go through it and see what else has happened. And then always make sure, I put an arrow here, always make sure you are working with the most current contracts. As realtors, we are supposed to work with our GAR contracts. It is okay to mix contracts. So if someone is not a realtor and they're a salesperson and they send you an offer on 2022, you can either ask them to, hey, do you mind? My brokerage requires me to use the most current. I can retype this on the 2023, or you can send it to them so they can retype it on that form. I like to do it myself. That way I know it's correct. And not to say that theirs isn't correct, but that I know I'm using the right forms. But if you have someone who sends you a 2022 or a 2019, you can mix forms. Or if they send you the RE forms, that doesn't have as much protection, you can mix them. As the broker, however, we would prefer you to get them to switch over. Natalie, you've got your hand up. Go right ahead. Unmute yourself and go right ahead.
Hi, Deborah. So I have a client who wants to use their own form to submit an offer. His attorney writes his contracts. So what can I do? He refuses to use a GAR form because his attorney is putting language that's going to protect him to send to the seller.
Yeah. So once you get that offer, this usually happens. I was going to ask you, who's the attorney in the transaction? Because usually, for those of you that are on this Zoom, you've either had this happen or you will have it happen. So you're going, what? It hasn't happened to me, but it will. Yes. The longer you're in this business, one day you're going to have an attorney client, or their family member's an attorney, or so on and so forth. So go ahead and take that contract. You as the professional need to review it and make sure that it protects all parties. If that person is just writing something that they wanted inserted, you could always say, look, I don't have a problem with it. I can still do the GAR form and just add that as a special step or an exhibit, whichever applies. But if they're just refusing, then it's your responsibility to go ahead and take that offer or take that form and add our GAR forms in that are needed. Like you'll need to add your affiliate business disclosure. You'll need to add the seller's disclosure, things of that nature, things that they wouldn't have. So, but I would review the contract and make sure it's not putting yourself or the brokerage in any, or the client that you represent in any kind of jeopardy. Does that answer your question?
I think so. So the purchase and sale agreement itself can be the attorney's version, but supplemented by whatever other GAR forms we need to use. Okay.
Yes, but you really need to review what are they writing, because typically when an agent calls me to say, hey, they sent this instead, and I review it, there are things in there we're not going to accept either. So you have to review it. And since I don't know what's in there yet, or what they're talking about with you, then you just need to read it. If it's harmless and it's like, okay, so you want that in there, we already have that in our contract, but if you want it written that way, that's fine.
So do I send it to you for review to make sure the brokerage is not in trouble?
How about you read it first?
Well, no, I would, but
yeah, read it first. Yeah, if you think there's something in there that you need to bring it to me, sure, that's not a problem.
Gotcha.
Okay.
Gotcha. Thank you so much.
No problem. Thank you. All right. So the first form that was changed was F-107, authorization to show unlisted property. This form is typically used when you're working with a for sale by owner. If you're working with an iBuyer situation where it's not listed yet and you want to get a cash offer, the intent of this form originally was for sale by owner. The only thing they changed is no brokerage relationship between owner and broker. They've changed all the wording in the body of this number 13 of this form to owner. So I just want you to be aware of that. Not a big deal, just the words change in case you say, wait, there's an error here. It says seller and then owner. Who is that? I know you guys are smart enough to realize that's one and the same, but I know I'm going to get that question. So I just wanted you to know that. F110, this is a beauty. I just took a Seth class last week, and it wasn't a contract class as much as it was a case study class. And I love taking that class because he puts different scenarios up, and I swear every scenario he put up has happened to us. I was like, is he using our case studies? But this one hasn't, or actually it has happened. I did have an agent call me about this, but anyway, in all of the brokerage agreements, seller agreement, buyer agreement, non-exclusive, exclusive, this same letter K and L was added. And basically it was made a little clearer, I should say, that we know nothing about nothing. You don't take our advice. That's one thing. But the other thing is, if you go to a property and you happen to get hurt, you hold us harmless. You hold this, the buyer and the listing agent harmless. In the listing agreement, it's in there as well. What happens if someone gets hurt on a property? That's what homeowners insurance is for. And they're going to have to go after the seller, or they're going to have to go sue. But what's going to happen when someone gets hurt? They're suing every deep pocket they can find. So in last week's class, he gave the scenario of, he put up a picture of a living room with a sunken, it was a sunken type dining room or living room. I think it was the dining room with a little step. Now there was a picture of this step in the MLS. And all of us, I hope, when we're pulling property, we look at the pictures, we read the directions on how to show, we look at private remarks. If you're not doing that, that should be part of your system. And clearly there was a picture of a room with a step down. And so the buyer's agent brought in her clients, and they happened to bring their elderly mother. And they're in the kitchen, they're about to go into the dining room, and we're all trained to let, if you're not trained, you're going to learn something here, to let the client go first. You can watch reality TV and things of that nature, and you see the realtor walking first and saying, this is the bathroom, and this is, like people can't figure out what the bathroom is, but you know what I mean. I don't walk first. I say, let's go to the next room, or I let them walk alone. It just depends on what the property is. This was a vacant property, by the way. The husband and wife stepped down first. The mother was behind them, and she fell. When she fell, and you probably were expecting that, for me to say that, what you're not expecting me to tell you is that she died. They had to call an ambulance, took her to the hospital, and she died. They sued the brokerage, they sued the homeowner. The insurance company offered $300,000, and that's when they got an attorney, and they want millions. So this is currently a pending litigation. So there were lots of discussion about, should I have put up something saying caution? Should I have put something in private remarks? Look, at the end of the day, if you walk into someone's home to list it and you see hazardous conditions, do something about it now. Slippery rug, terrazzo floors on a patio that might get wet when it rains. Just little things like that, that common sense would tell you, we need to correct this because we don't need someone falling through the deck or slipping on some tile. I had an agent call me one time where the agent had her brand new Apple Watch and brand new iPad and walked into the house and slipped at the foyer. There were steps down as you came into the home, down into the foyer, and she fell. She wasn't hurt or anything like that I remember, but she was telling the agent, you need to replace my watch and you need to replace my pad. No, because we're not, was it clear for her to see that when you walk in, there are steps to step down? Were you on the phone? We don't know the conditions. There happened to be workers in the home that didn't corroborate her story. So The other thing too is be real careful. People know how to throw themselves in front of cars or insurance or slip in the grocery store. So just be careful that if you see something in the home that you need to address with the seller, or if you're the buyer's agent and maybe no one noticed and you notice it, just give the agent a courtesy call to say, hey, I moved that rug in the kitchen because it didn't have a gripper on the bottom and people kept slipping on it, and we don't want anyone to get hurt. All right, any questions about that, concerns? Anyone else have a similar story? All right, so we'll move on. Just remember that lawsuit has not been settled yet, but lawsuits take years. They don't take weeks or months in some cases, unless someone decides to take some type of money, concession. All right, exclusive leasing management. Now, I was supposed to have Willie Nelson in our office, who is, I believe he's on the ALC, and he's also a productivity coach. And he said that he's getting a lot more questions about leasing, and we do plan to have a leasing class in Midtown. We're going to bring in some outside sources as well, like ProMove, to talk about how you submit your client to them, how you get paid, things of that nature. This is not an area that a lot of you on this Zoom have had to deal with. And now that rents are so good, and I'm not quite sure what they're paying because I don't really handle leasing, but for other people anyway. But at the end of the day, it's something you need to have under your hat in case this comes about. I would highly recommend, and if you have the time and the patience, I would highly recommend going to Georgia MLS and clicking on the new tool called Realty Beast or Real Beast or something like that. They have a, 4, 7, 11 module lesson on great opportunities, great tactics for handling leasing type clients. The last module is for Texas, because I believe this company is out of Texas. You don't need to take that one. I took the entire thing. The sessions are 20 minutes to 1 hour, depending on the topic they're talking about. So I kind of did it over 5 days, a couple of hours or a couple of minutes that I could go through it if I wasn't busy or had to stop and go to an appointment or stop and help an agent, and then went back to it. So if you've got the time and you're really interested, it is a really good program. There's some really good scripts in there, good practices. They have an upsale or upgrade version called Pro, if you should want to do that. I didn't check into that. And they also have webinars that they advertise. I've not done any of the webinars. I just did the self-pace. So if you get that opportunity, just go into Georgia MLS under tools and you'll see Real Beast, and you can set up the modules. You don't have to do all of them. You may just want to look at the ones that pertain to you, but I went through it to see what's there. And I thought it was very good. Any questions about this form? This form, the only thing we changed was that the manager's liability to the owner shall be limited to the total compensation paid by the owner to the manager in 6 months prior to the owner asserting a claim for damages. So in other words, just like we talked about slipping and falling, if there's any kind of damages or anything like that, they have 6 months prior to the owner asserting a claim for damages. And 6 months was what was added. Previously, it was 3 months. Okay.
Hi, Miss Deborah. I'm completely ignorant to this form. I haven't seen it before. So the leasing/management agreement, is that like if I help a seller lease out
Yes.
their home and I'm also managing it for them in like the capacity of a property manager?
Yeah, but you know what, the only reason I brought this up, because there are some people that do that, but you've got to get permission to manage, because we're going to be responsible for your license if you're handling management properly. Because if you're not, when I was team leader in East Cobb, I had an agent that did that, and she had been sanctioned by GREC for mishandling of security deposits. She was already hired by the time I became team leader, so I didn't know that until there was a problem. And at that office, I was the qualifying broker. And when they contacted me, she had violated what she had already been sanctioned before, and she lost her license. They'll slap you on the hand once. You're not gonna do it twice. So she did lose her license. So yes, that's what this form is for. So check out F-128. That was the only thing that they changed this number from 3 to 6.
We don't need a CAM license for management. I thought you had to hang your license and do the CAM if you want to do property management.
That's why I'm saying you need to take that offline for us to talk about that.
Gotcha. Thank you.
There are some people that I've heard, I don't know that for a fact, that are doing some kind of management. Either they've gotten that approved with Brett or Lee or whatever. I don't think so, but I don't know that for a fact. They didn't run it by me. Okay. And that's a problem with E&O insurance too, because you need to have your own insurance and things of that nature when you start getting into that management realm.
Yeah, not doing that.
Because our E&O is only going to cover certain things for us as agents under the brokerage. Under the purchase and sale agreement, number 2 says that the purchase price can be paid in such method that the attorney allows. There was a time when I started in the business, you brought a check or you brought a money order or you brought certified funds. No one wired, not really. Every now and then someone would, but now that is the mode of income that or dollars, that the method that the attorney wants. So if the attorney says, I won't accept anything other than wiring, they have the right to do that. So they just wanted to make that clear, that it's about what the attorney will accept, not what we tell them. Because I'm used to saying the word check, which we all know that dates me. But they still exist. Closing costs, under the section of closing costs of the purchase and sale agreement, B and C was added to really clear and, or not added, but clarify what is paid by the seller and what is paid by the buyer. Can you change this in the contract? Yes. We all learned that we have a pre-written contract, and if we write a special stip or add an exhibit that would change something in the purchase and sale agreement, then what prevails? The special stip or that exhibit that you've added. But the purchase and sale agreement already makes very clear, sellers paying this, buyers paying this. And the real reason that this is here is because sometimes, let's say a wholesaler says, I'm going to buy your client's listing and I'll pay all closing costs. Well, all in my vocabulary means all. All means B and C. So if you get someone who says all, be very clear about what all is. Does that include under number 3, B and C? Okay. And I would be careful about that when someone says they're going to pay all, because sometimes that gets a little tricky at closing. All right. Any questions about that? I know you've seen that where people say all. Also under the purchase and sale agreement.
I did have a question about, aren't there some things that the seller cannot pay on behalf of the buyer?
Yes, that is true. Like in a VA loan. Like in a VA loan, there are some things like that, but that's why I'm saying be very careful when someone says all, can they really pay all? So the contract already tells you what the seller can pay, what the buyer can say. So I just want you to be aware, it's already in pre-written, but if someone says all, and you know full well that the VA contingency says the seller has to pay for XYZ, which we will see, then how does that, which one takes precedent? Because all is going to be written as a special stip because there's no all in our contracts. Does that answer your question? Hello? I don't know who asked that question.
Yes, thank you.
Okay, that's okay.
My face probably goes down.
Okay. All right. Under disbursement of earnest money. So here's where I'm going to talk very quickly about the 10-day letter. When you are negotiating back and forth, you go binding, then something happens in the contract where someone cries foul, typically the seller, and they're not going to sign your termination because they want the earnest money. the first thing you want to look at is, well, the first thing I suggest all the time is, look, everyone's in their feelings, they're in their emotions. Let everyone sleep on it if you've got the time, and then come back and say, let's be sensible people. Okay, we're talking $5,000 here. We're not talking 50,000. And sometimes we are talking 50,000. Okay, so at the end of the day, everyone's all up in arms about this earnest money. Well, if the holder is your broker, which Tom prefers, I'm okay with either the attorney or the broker, but he prefers, because most attorneys, we all know they get paid by the minute, and they're not going to put a whole lot of effort into reviewing your contract and where it should go. If it gets to be too much for them, they're going to interplead it. Now your $5,000 has just been eaten up by the courts, because everyone's got to hire attorneys and all that to fight over $5,000. So the earnest money being held by attorneys was not really a thing for many, 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 many years. And now it's a thing. So what it is saying is, if you have a situation, your first thought is to call the broker. And usually by the time you get 3-4 sentences into asking me a question, I will usually ask you, who is the holder? Okay, who is the holder? And so the holder might be the attorney. Well, guess what? The attorney has to discuss this with you. You can still discuss it with me on how does this work and what should I do and what to look for. That's not a problem. But I don't write the 10-day letter. So let's say you don't agree to sign the termination. Both agents have tried to work it out to try to see if, hey, can we split the commission or split the earnest money? Can we work out whatever the problem is? If none of that works, then you resort. Do not go right for calling the attorney and calling the broker. Your job as a professional is to see if you can bring everybody from a 10 to a 2. And if you can't do that, and you've exhausted everything as a professional, that's when you ask for that 10-day letter. All right. And what'll happen is you will send the information. I need the broker's name. I need all the parties. I need the contract or the address, at least, so I can go on command. I need to know what the situation is. And then I have to review all the information. Now, you're going to be compelled to send me every text you've written, every email you've written. I do not want that. I'll ask for what I need. The main thing I need is the contract, because then I'm bombarded with your entire laptop when I don't need all of that. I don't need the drama, the arguments, none of that. I just need the facts, and I want to look at it. And then if I have questions, then I'm going to come back to you and say, did this happen? Did this happen? Well, they don't get the earnest money back, or yes, they should get the earnest money back. Once that happens, I type a letter, and I have a boiler template that I've created, and I think Tom has one as well. And we put our decision in that letter, and we send it out to all parties by email and certified mail. All those individuals have the opportunity. Now, what they added in this paragraph is, you are also one of those individuals. You were not one of the parties. And it says any party, real estate licensee, or any other person having knowledge of or an interest in the disbursement of the earnest money. So it could be a plumber who knew something, and that's the reason you need the earnest money. I don't know why I said plumber, but just somebody outside of our little bubble of the contract. So now you can have evidence of saying why. Someone else can have it, but usually it's going to be the parties, the listing agent, buyer and seller. When that happens, the letter goes out, nothing can happen. And the question I usually get, can I put the house back on the market? The intent of the 10-day is not to put the house back on the market. Okay. But I know you guys are doing it anyway. And the reason being, because if someone wakes up on the other side of the bed the next day and they decide, I'm going to bring it from a 10 to a 2 and I'm going to move forward, and you've gone under contract with someone else, you've now sold the home to 2 people. Everyone's so quick to put it back on the market. If you want to, excuse me, put it back on the market, then you should really be trying to get everyone to stay in the contract and do everything in your power to keep them in the contract, instead of just throwing your hands up let's do the 10-day letter. And meanwhile, let's go try to sell the home again. Most people are lucky and that doesn't happen, but it does happen. Okay. So if you should put it back on the market, then I think that you need to tell the seller, we need to disclose to that buyer that technically a 10-day letter, think of it like we're in litigation. And we're not supposed to sell a house when it's in litigation. Think of it like that. So, because what if the attorney, if they're holding it, they decide to just throw it into arbitration, meaning they're going to send it to your county court, and now you guys have to go to court to fight it. Brokerage is out of it, attorney's out of it. Now everybody has to hire an attorney to go to court to fight over $5,000. Okay. And if that's the case, now you really are in litigation and you shouldn't be selling that house. Because the judge could say, you need to sell that house, you're wrong. Anything could happen. I'm just throwing things out, but the easiest way to remember this is try to work it out. Then if you can't work it out, then we do the 10-day letter. We have to wait for an answer. And what'll happen is if someone comes back with more evidence that myself or an attorney or Tom need to reconsider, we have to write the response back again, and that's another 10 days. You see why you shouldn't be putting it back on the market? Because something could happen in those 10 days and maybe even 20 days. And now this other person is going, well, is that over with? What's happening? You know, so I would be very careful about putting homes back on the market. I never have done it. It's also a deterrent. It's to say, well, Mr. and Mrs. Seller, if we do this, please know that I can't put your house back on the market until we resolve this, because we technically have not terminated. You didn't get a termination sign, guys. You didn't terminate.
So at any time, as long as they terminate, then everything goes away. Even if you decided you're going to move forward with litigation or whatever it is, as long as that contract is no longer binding through a termination, then everything is all good.
Terminates. But if you're doing a 10-day letter, you haven't terminated because one party decided not to sign to give you your earnest money back. You signed,
right?
But the whole form, it's one whole form. The top part talks about I'm terminating. The bottom part says I agree. It says or at the top and at the bottom. And says seller and buyer agree that the earnest money goes back to whomever it's supposed to go back to. If they don't agree, you've got a dispute. Where do we handle disputes? In court. Okay, so you've got to think of this paragraph, this situation as litigation, and that's how you should be explaining it to your seller, that if we keep digging our heels in, we're going to have to go through some type of court. As you can see, number 3, an order of a court, arbitration, having jurisdiction over any dispute involving the earnest money. That means we don't agree. So we have to figure out how to agree. And so the best thing for you as a professional is to say, look, let's put, if you're in my office, you've heard me say, someone has to stay sane at the table. Don't get caught up in the tears and the this, unless you are the one doing that, then that's different. But you have to be kind of that mediator for everyone to say, all right, let's put our calm heads on and let me explain this paragraph. If you want to move forward, buyer and seller, we can do that. But let me tell you what your options are. And here's what could happen if the attorney or the broker comes back with a different scenario. Okay. Anytime a seller receives the earnest money because of a breach of some sort, and it's over $600, that's considered liquidated damages. Where do we get liquidated damages? In court. So this is kind of a legal situation, and we're putting houses back on the market. So if the seller gets more than $600, we must have a W-9 before issuing the check, because that's not income coming to you or the brokerage. That income is going to the seller, and we need to let the IRS know that. So if your buyer happens to lose their earnest money, or if you're the listing agent, not really the buyer, but If you're the listing agent, you need to let the seller know you're going to have to fill out a W-9 as well from the brokerage or whoever is holding the earnest. It could be the attorney, but they're not going to release that money until you do that. So if they put up a stink about that, we'll just hold on to the money until they give us the W-9. Okay.
At what point can you relist? At the time that there is a decision made? They don't have to receive the money if it's in the seller's favor or whoever's favor it's in, as long as the
Correct.
determination has been made, you can
Yes.
go back that day.
Yes. And here's the thing. If you decide to put it back on the market, that's what private remarks are for. To tell the other party something. That's why it's very important to read them. And I know a lot of times agents don't read that far down. I'm not sure why, but you need to read those. Sometimes there's some nuggets there. And so if I have a situation that I'm in this scenario, I might say to the seller, look, we can put it back on the market, but we need to, do you have a problem with me putting in private remarks that we are under a earnest money dispute that should end on July 1st? That way, and you might say, oh man, then they might not make an offer. And they might ask why we were backing out, why there was a dispute. That's why you always ask the seller first whether they want to do that. If they don't want to do that, then you're technically putting a house on the market or back on the market without disclosing that there's a problem. And so if you happen to sell the house twice, now you're going to have egg on your face trying to figure out, why didn't you tell us you were fighting over earnest money? We would not have bothered, because what was supposed to be 10 days is now 20 days. You see? So that's why the intent was not to put it back on the market, so you don't have to go through that. But at the same time, by not putting it back on the market, it also pushes the seller to say, oh, I don't want to keep my house off the market over $5,000. Put it back on the market and let's just move on, But there are a lot more sellers digging their heels. Well, you know what? I think there's more buyers digging their heels in now than I've ever seen in my career. But usually the sellers will dig their heels in. All right. Also in the purchase and sale agreement, the buyer's inspection rights continues even after due diligence or the right to inspect. So yes, you have a due diligence period where you can ask for things and so on and so forth. But if say that buyer is a renovator and they need to come in and have their contractors, vendors, measurements, tests, soil tests, any of that kind of stuff, if it goes outside of their inspection period, this paragraph says they still have the right to access, but they just need, or access, but they just need to make sure that they give proper notice, okay, upon prior notice to the seller. And you can do that with a notification form. A lot of you just call and say, hey, my buyer wants to come over tomorrow at blah, blah, blah. You're okay to do that. But again, litigation is through the roof right now. And it's because nothing is documented. No form was signed. It's all he said, she said, and a text, which, by the way, does not hold up in court. Okay. I know it's a lot of paper and a lot of forms, but that's the reason we have over 600 forms, to protect you.
I'm sorry, did you say text messages are no good in court as far as documentation?
Correct.
Emails are though, correct?
You can use email, not text.
Do you know why text is not? I'm curious to know why, if you know.
Because they haven't approved it yet. Text can be manipulated, emails can too, but Seth kind of touched on that. I guess at some point they will. Text didn't exist in 1996 when I got my license. But email did. I think they are still trying to evaluate whether text should be a form of proof for us in contracts. I don't trust the text thing. There's too many things that can manipulate. And as we move into the world of AI, it's going to get real tricky out there, you guys. Because I've been reading up on it, and NAR is exploring it. I think it's fabulous, all the things I've been looking at, but the misinformation, and our industry is not good at reading and making sure things make sense. They just click, click, send. So text, things of that nature. You slow down a little bit more when you do an email versus a text. You're LOLing all over the place. And so I think that's another reason why that one is not so popular yet, or in our basic contract. If you look in our contract under communication, it tells you you can certify mail, you can do it in person, you can do email. But I don't know that text is ever going to be one of them, but I could be wrong on that. I think if text can be secured a little bit better, could be. All right, so purchase and sale disclaimer: buyer and seller have not relied upon any advice or representations of the broker other than what is included in this agreement, and broker shall have no duty to inspect the property for defects, hazardous conditions, repairs, blah, blah, blah. I am finding more and more, here's what I know your intent is. Your intent is service. Your intent is to say, I'm a great agent, I'll go above and beyond for you. But the above and beyond costs you money when you do it wrong. And the above and beyond costs you money when all of a sudden your friend, also known as your customer or client, turns on you. Okay, if it hasn't happened to you, it will. I don't mean to be doom and gloom. It's just that responsibility and accountability is short these days. And so if it costs somebody money, they would rather point to you to say, well, you did that, you told me that, that kind of thing. So how many of you realize that you have this form? It is F828, and it's the broker to hire vendor. So it's okay to have customer service. But if I had 2 calls this weekend where the agents were calling me about something else, but I'm the kind of broker that reads between the lines of what you're really saying or what you're really not asking. And usually that's really the situation. And twice I heard both of these agents say, well, I went ahead and hired the inspector and blah, 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 and kept just glazed over that like it was nothing. So here's a real example of a person that I brought to Keller Williams when I was in East Cobb that took care of one of their friends / clients that was relocating to Georgia. The house had a pool, hired the pool inspector to help out their friend because they were like, I'm not going to have time to do that. Can you do that? Yeah, I could do that. Pool guy came, said the pool was fine. Friend / client closed. Pool had all kind of microscopic cracks. They sued Keller Williams. Why? Because we hired the pool person. Okay, now, was that our responsibility? No, we don't know nothing about nothing. You don't take any of our advice. You have to check it out for yourself. Okay, and so they just went ahead and did their thing and ordered this pool guy. When I have someone who doesn't have time or they need me to help them find someone, I use this form, what service is being provided, the phone number, and how much it's going to cost. And then at the bottom, you'll notice there's a signature there. And look at that highlighted section that talks about furnishing any names. How do we furnish names to our customers and clients? What do we give to them? Anybody?
Just a list, like a word file?
Like a vendor's list. This is my favorite plumber. This is my favorite this and that and the other. Then when they use those people and they don't like it, they want you to fix it. They want you to pay for it. You gave me this person. They came out. They don't want to sue the person who actually did the work. It's always the realtor for some reason. I'm going, I didn't swing that hammer. All I did was help you out because you're working to maybe shorten your load by giving you this list. If you use this form and you see that highlighted section, it says, not only did you ask me to find you an inspector, but attached also is my vendors list, but I need you to sign this to say, I know nothing about nothing. You can even say, and I've done it, I've used a couple of these people for my personal home, and some of my clients and customers have used them, and they've had good success. Because you want to say nice things about your vendor, right? But at the end of the day, your vendor might get up on the wrong side of the bed and maybe short of a contractor or a subcontractor and send somebody out there who doesn't know what they're doing. They cause a problem and now they want you to pay for it. GAR protects us, guys. we have a form for everything. We're not using them. We're just saying, I just want to help you. I'm just going to go and do it. I'll make the phone call for you. We have the forms, use them. And you also notice it says copy to the person signing and then a copy to your broker, which will be uploaded to Command. Just in case I get a call saying, I'm suing you because nobody told your client to hire the pool guy. Oh, I'm sorry, I have a form here that you signed that we were allowed to do that for you. You see how that just nips that in the bud? All bets are off.
I have a question.
Sure.
So even if they give us authorization to hire the vendor for them and the vendor still does a poor job, we're not in the same boat if they're dissatisfied, like with the pool situation that you
They'll
described?
come for you. They will come for you. But in a court of law, guess what I now have? Guess what the brokerage now has? This form, which says, giving you vendors, you hold us completely harmless if it doesn't work out.
Gotcha.
That's what a judge is going to see, not you standing there with a text. Okay. We're not going to do that. I'm not going to court with you. If you don't have this form, like, we're not going to win this one. So you might as well we need to figure out how we're going to make this work. All right.
Gotcha.
Again, in the purchase and sale agreement, they changed under the definitions client and customer, just in case people don't understand the difference between the two. Sometimes I think the agents need to read this. A client is someone with a written brokerage engagement agreement. A customer, we have a customer form, but you're also only supposed to perform ministerial acts. And that's on the following forms also, 210, 213, 228, anything that has to do with the brokerage engagements or the sales contracts. It has these two letters have been added. Okay, seller will be liable for such damages, including attorney's fees, reasonable incurred as buyer can prove because of seller's wrongful failure to vacate. This happens a lot with temporary occupancy. Temporary occupancy has been abused so much now. When I started in the business, we didn't even have it. Everyone showed up at the closing with a U-Haul and keys, and they were out of the house a day before closing. When the market crashed and banks were going under, deals were falling apart at the closing table because the bank failed. And so seller said, I'm not moving out of my house until I have my money. That's reasonable. 30 days, all this nonsense we were doing during COVID, it's way too long. It's way too long. A weekend, a day, 2 or 3, that's fine. That's fine. But if a person holds over and they go, well, it's still my house, I'm staying here, I'm blah, 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 blah. If you have to evict them or any of that kind of stuff, they're going to be liable for attorney fees. Okay. VA loan. Remember, we talked about the VA loan earlier. Any reinspection fee. So what happens in a VA? VA is very conservative, and let's say they don't do inspections. What they're doing is making sure that if the home follows VA guidelines, and if they were to come to the home and say there's wood rot around the door, that's a common one. There's wood rot around the garage. That has to, the house appraises as long as that is fixed prior to closing. And then I'm going to have to come back and re-inspect it. So let's say that inspection, that appraisal was $600 and the re-inspection is $150. It's saying right here. So someone said, hey, what about any closing costs that the seller has to pay, and so on and so forth. This is an example of one in the VA financing contingency. Any re-inspection fee necessitated by seller correcting infestation of termites, could be wood rot from the termite infestation or whatever, that's going to be paid by the seller on top of whatever contribution of closing costs they have given. That is new. That's new in there. So if you're dealing with VA, make sure, and you're the listing agent, that they know that. So again, that's a good thing to inspect prior to putting it on the market to make sure everything's good. Earnest money exhibit. This changed from 3 business days to 5 business days. I think the attorneys didn't have enough time, so that's probably why that was changed. Not a big deal. I don't know if you guys are even paying attention to that when you ask the closing attorney to hold the earnest money, the entire contract, not just the purchase and sale agreement, all the exhibits and everything must be given to that attorney if they're holding the earnest money, and they have 5 business days to get this signed and back to you. Same thing with the F511. So if you do a F510, you're also supposed to do a F511. And everything that used to say 3 now says 5. This is the unilateral termination we were just talking about. When you don't get it signed, we talked about the 10-day letter. But let's say you do get it, no, I'm talking about just termination now. If you terminate and someone says, I'm just going to terminate. Well, you can only terminate if it's the due diligence period. This is unilateral now. There's a mutual and there's a unilateral. Uni means 1. So in a due diligence period, before that due diligence ends, you have the right to use this form. If there's a contingency, hey, I just found out I'm not going to get my loan, and you're within your financing contingency, you can use this form. Any other default that you might have in your contract before the time period ends, you can use this form. And then, of course, any other lawful reason. A good example of a lawful reason would be a military person who's been deployed, because it does say they can cancel without any penalty. That's a good, there's lots of them, but that's the one that comes to my mind. Okay. And then, of course, the signature of the person giving the notice. Now, I wanted to show you this video. I'm not going to do it today. I just wanted to show you a picture of it. If you go to FMLS, you can watch the register status and coming soon status. There was a lot of question about doing coming soon and whether you could show other people the home and things of that nature. You can now advertise it. You cannot show it. You can still receive an offer, but you can't accept it. So if you'll go on FMLS, and it's usually on that front page when you log in. If not, you can just go under events or something like that, and you'll find this video and you can watch it. It's only about 2 minutes. And they explain all of that. So I just wanted you to see that that was available to you. And then the other thing I want you to be aware of, that we've got a lot of scamming going on. I don't know, I usually have news in the background, and I only focus when there's something that I see you, Calandra, I'll get you in a second. I only listen when if it's real estate related or something like that. And there's been a lot of scamming on text. There's been a lot of people using your listings on Craigslist and then taking money for rental deposits, only to find out this one actually happened in Georgia. This is a real one that recently happened, and in Carroll County, where the person took the listing. I think we had a scenario in our office a couple of weeks ago where they went in and they said, hey, what are you doing in this house? And they were like, well, I paid a deposit, I moved in and all that, and it was fake. So they had to call the police and file a police report and all that kind of stuff. So please, 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 if you're handling leases, please watch your marketing. Please be very careful about just advertising the address and things of that nature out there. Be a little careful with social media, what you're putting out there with someone else's home, because the scammers are collecting that information. The situations I've been hearing coming to me have been, I put it out there on Instagram and this and that and the other. Well, what are you putting out there? There's nothing wrong with showing the pictures and all of that, but don't put the address. You know, you got to protect your client a little bit as well. It doesn't make sense. If they want to know the address, then that's when you go into let me talk to you mode and see what you're looking for. And, you know, then I'll give up the address. There are plenty of sites that you've gone to other than real estate that they want you to log in before you can see anything else. They're trying to protect the information on the other side of that contact form and also collect your data. But at the end of the day, this is why this exists, because it starts with us giving too much information online and social media and so on and so forth. And then some of it is not your fault. Some of it is because our MLS has sold the rights to some of these companies to get the feed. Then it is giving the address, it is giving all the information. So anything you could do to keep from this type of thing happening, I would suggest you do. You're not going to be able to stop it because we do have feeds that come from our MLS, but this is becoming very popular, even more so than it ever has been, with stealing listings and collecting money from, unsuspecting people that are, especially people that relocate. They're driving their kids and their U-Haul across the state, think they have a place, move in, only to find out it was a scam, which is extremely sad. All right, Condra, you had a question.
Yes, right on time. Thank you, Deborah. My question is, when you were just talking about in the, I guess just MLS in general, and you're talking about things that are coming up, but when I go out to the MLS systems and I see pending status, I've searched for the legends to give me the definition of what that is, and honestly, I have no idea what pending means, because it looks like it's active, like an active listing sometimes.
AUC, active under contract. So we used to have a term called contingency and contingency kick out, and it would still show up as active. And all that means, and AUC means, hey, we still have some contingencies to take care of, but I still want to show the property. I still want to receive offers. Okay. Then once the due diligence is over and that contingency is fulfilled, FMLS switches it to pending, meaning that's it. So when it says AUC, most likely there's a contingency with a certain amount of time, which you could call the agent and say, hey, I see you have this under AUC. What is the contingency? They're probably going to tell you it's due diligence most of the time. Okay. When does that end? Oh, it ends on Saturday. When Saturday shows up, the agent is not going to change it to pending. FMLS will, because when you go in to do your pending or your AUC, you're going to put a date. They're not going to let you just use AUC randomly. You've got to put AUC, because I use that, and I put a date when, let's call it due diligence is over Saturday. I don't have to go back in and switch it to pending. FMLS will automatically do it based on the date I put in.
Oh,
If
okay,
there's
thank
no
you.
contingencies to deal with, it goes straight to pending. For instance, hey, I'm buying your house. No, I don't want you to pay any closing costs. I don't need an inspection. I don't need a financing. I don't need an appraisal. That's pending as far as I'm concerned.
Mm.
There are no contingencies.
So it goes from pending to close after that.
To sold, yes.
Gotcha.
And we
Okay.
don't do that when we do our Form 118 to inform FMLS that we've closed, and they know they're going to get paid their 0.0012%, then they switch it to pending for us.
Awesome.
In Georgia MLS, I believe we switch it to pending, because those are two different.
Gotcha. Thank you so much.
You're very welcome. Anything else from anyone? Well, I am a new mentor on NAR, and I have a 1 o'clock. So if anybody has any more questions, I can stay for like another minute. But if not, I'm going to have to jump off and get on another Zoom. I thank you guys for showing up, and look out for that. If you need it, look out for that leasing class, where we will go over all the leasing GAR forms and different scenarios on how you get paid, when you don't get paid, how you fill out the forms, all that good stuff. We're going to be doing that.
Thank you,
tell
Deborah.
NAR that they are lucky to have Miss Deborah Blue.
Oh, hey, Barbara. Yeah, they asked me to do this, and I was like, what does it pay?
Blood, sweat, and tears.
I know. But and they need mentors, because they usually just pair you one-on-one, and they've given me 2 people. And I'm like, wait a minute now. So I've got to go on the call at 1 and get trained, I think, as to, well, what do they want me to do? What do they want me to say? I'm like, I don't think I'm that much of a mentor, but okay, we'll try it.
Yes, you are. Yes, you are, Deborah. They are fortunate to have you.
Well, I'm excited. It's just another little, feather in my hat of, I like to teach, I like to train. So if there's someone I can help, I'm excited about it. Thank you guys for being with us today. Next time it'll be Tom in a couple of weeks. And if you have any topics that you want us to cover, please send them to our email. We want to make this platform great for you. and talk about the things you want to talk about. Thanks so much. Have a great day.